Hello. Hi, hi, hi. We are back. We are back with more true crime. Hello, everyone. Can you see me? Can you hear me? Are we all good? Hello, hello. It is the 26th. It is Thanksgiving Eve. Busy, busy, busy. I know I was a little late because I just did an update on the David case and Celeste Rivas. Go watch that video. It's like 9 minutes. I just posted it on my videos tab. Breaking news. And then also, what was the other thing I was going to tell you guys? Something else about another case, but now I can't remember. Nonetheless, I made a video about that. Definitely go check it out. Welcome back. Hello, hi. Thank you for being here. I appreciate it. Please hit that like button. Do all the YouTube things, that help the channels out. Hello, hello. We were up late last night on a 6-hour live. Hello, Cree. Hello, Kara. Hello, Evie, Debbie. Hello, hello, hello. Let me know what you guys are doing. Happy Thanksgiving Eve. What are you guys doing tomorrow? Are you hanging out with your family? Are you staying home? Are you avoiding your family? Are you just eating a bunch of food all day long? Are you going to be tuning in onto the YouTube streets? What is everyone doing tomorrow? Let me know. I think I'm gonna just be chilling. So I might stream, maybe not, maybe just post a video. We'll see. We'll see. I do have to get a pie in the morning, so I'll probably be doing that. But I'm hoping to be live or at least be on YouTube tomorrow, at least for a little bit. Hey, Yvonne, good to see you. Okay, so we're going to be watching Kelsey Fitzsimmons' case. So if you're not familiar with Kelsey Fitzsimmons, another corrupt case out of Massachusetts. Kelsey Fitzsimmons was shot and arrested, and her baby has been taken away from her by law enforcement and her what was supposed to be fiance. She was going through postpartum depression, tried to unalive herself, and basically she is locked up in jail now because she's a danger, et cetera, et cetera. We have covered the Kelsey Fitzsimmons case here. I'm going to give you guys a little details about the hearing. I got a lot of documents. I know I've read a lot of them already. I know we read the most recent 38-page brief. I don't know that I'm going to read that again. I kind of want to though, but I also know we read the statement from her ex, and we're going to read that again tonight too. Or today. So we're just going to go through those documents. But we're going to watch the hearing first. And that hearing was yesterday, November 25th. She appeared in court via remote video for basically a hearing on discovery in the trial timing. The trial was set for February 9th, 2026. Absolutely, we will be following that. With that being said, I did want to let you guys know we will be streaming our first trial next week. So every day, all day until it's over. And I'm really excited about that. So I hope you guys tune into that. It's the Brian Walsh trial. So we will be streaming it here on Mellyverse. And I'm really excited because I was supposed to be doing Courtney Clenny, but Courtney Clenny has been rescheduled. So we're going to go on to the Anna Walsh and Brian Walsh case. If you guys are not familiar with that case, don't worry. We are going to be covering it this weekend, deep dive. So definitely make sure you turn on your notifications. Back to Kelsey Fitzsimmons. During this court hearing, the court addressed requests by her defense records, including communications and other evidence from involved officers, and whether any invoked their Fifth Amendment rights. She has pleaded not guilty to a charge of assault with a dangerous weapon. The defense says the gun was never aimed at the other officers. She says she pointed it only to herself during a suicidal moment. After the shooting and her indictment, Fitzsimmons was 1 point released on strict conditions. We know the whole scram thing. They basically locked her back up because she could not blow into the scram device, which is an alcohol monitoring device, but she was shot in the chest, so she couldn't. Why does this hearing matter? It matters because it sets basically a concrete trial date, and it moves the case further from pretrial motions and procedure delays towards a full trial. So it also represents a milestone for both the prosecution and the defense. They now know when the case will be heard. And she's going to be locked up until then, I think, unless something happens. Which is really sad because she is going through postpartum depression and she has not been with her baby. So that was what the hearing was about yesterday. I'm going to pull it up. This case is heartbreaking. I know. We are home, just myself and one sister. Yeah, I'm just home with my parents. It's going to be low key. So I'm kind of excited about that. I don't have to deal with people and other family members, and just do what I want. So I'm looking forward to it. I'm going to pull up the hearing and we're going to watch this. Let me see if I can make it. I'm so overstring, and I tell you guys this like every time. There's just a pain in my butt. Um, can you guys see it okay like that, or is it too small? Pause. Um, I don't know. Let me see if this. Oh no, it's too big. I'm trying to make it to where. Oh, I don't want to be in the way of it either. Okay, we'll go back to the other one since I can't figure my shit out. Can you guys see it that way? I hope so. Am I bigger than it? I could make it. I can fix it. We stayed up late last night on a hangout. If you guys haven't watched it, there we go. Um, go back and watched it. We covered some really good cases. We're going to be getting into Kenzie today. I know, it's what you guys wanted to hear. We're going to be getting into Kenzie probably later as well, and then the Christopher case that I want to cover. So hopefully after this one, we can move on to those. Let's watch this hearing. It's not very long. The audio for a little bit, but just sorry. I can't control that. And then also this hearing, this judge is really rude and makes me really upset. Let me see if I can turn on. Sorry guys. Let me get to the part where it starts and I'm gonna turn on closed captions as well. Oh, there she is. Okay, I wanted to see that part. Are they gonna show Kelsey? I thought they were. Oh yeah. Did I miss it? Oh, there she is. Oh my goodness. There's Kelsey.
Hello, Your Honor. Timothy Braille on behalf of Kelsey Fitzsimmons.
Good afternoon, Your Honor. Martha Stolzny on behalf of Kelsey Fitzsimmons as well. All right, good afternoon.
They wouldn't let her be outside of out in the courtroom. I'm so annoyed. This is such corruption shit based against her, you guys. This judge is just so out of pocket.
Judge, can I ask as a preliminary matter if Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us at the council table.
No, I only do that for a change of plea, a trial, or an evidentiary motion to suppress, and I don't see why I should treat her.
So they just told her no, she can't come out from behind the glass wall because they only do that for specific circumstances. The sound will get better.
So the answer is she's here at your request, but no, I'm not going to let her sit in council. Otherwise, I have to allow that for everyone, and it presents a security concern. So if I do it for one person, I have to be consistent.
All right, if I need some time with her, Judge, I'm just going to have to ask for it.
Which, of course you can. You can go talk to her as much as you'd like. Okay, so this is on for trial assignment today.
Yeah, Laura says the other judge was way worse than the other hearing. I do have a playlist of Kelsey Fitzsimmons. I think they're both just as bad, Laura. Like, what's going on in this town? Like, what's with people from there? Like, I mean, not like civilians, but I mean like the judicial system. Like, I don't understand.
I indicated in the phone conversation.
There's a lot of corruption.
Back in October that we could try it anytime. So let's do that.
So, Judge, a couple of things on that. We think that's a little premature for several reasons. I have 3 outstanding discovery motions that we should go off to talk about today, if that's all right with the court.
It does get a little better.
Sort of are, though that sort of begs further questions about more discovery.
Well, I have one motion here for specific discovery.
Well, Judge, we filed 2 motions on August 26th,
Okay.
and I have copies of them here.
And what are they entitled?
There's a motion for court order disclosure and release of arraignment, and there's a motion the Commonwealth may well be in compliance with some of that or most of it, and so those are really the first
Sorry,
ones,
guys.
Judge.
What is that?
I forgot to give you a heads up that was happening with the sound. I know it leaves you like deaf.
Sorry.
Okay. The camera is allowed in the courtroom, but it has to be silent. No exceptions. Thank you.
The first one is the motion for exculpatory discovery, and that is essentially a Graham McFarland request regarding certifications by the officers, whether there's any prior incidents. And that is a predicate to a Rule 17 for that, so that we have a good faith basis, if any, to file a Rule 17 for any further information. And my brother's telling me that that's fully complied with.
Okay?
And I'll defer to him on that.
Okay.
No, I think I complied with my obligations under the.
Okay.
As far as that first motion, there are things in there that in the first motion that I do not agree to.
Okay.
And we can go through them if we'd like, but other than that, I do have.
Yeah, if you guys don't know, Tim Bradel is Turtle Boy's attorney as well as Kelsey Fitzsimmons.
A list of questions that we ask every potential witness, police officer.
Right.
Database, but that has all been complied with.
Okay.
But if he wants to talk about the first motion, I'm happy to do that. No action has been taken on it.
Which, when you say first, I've got 3 motions here.
Motion for exculpatory evidence.
Okay.
Exculpatory discovery.
So that's essentially what we're talking about, Judge, the Graham McFarland request. And, you know, it's also obviously a Brady request as well. So I think it's more than just, you know, Graham McFarland. It's any exculpatory evidence that's known to the Commonwealth, whether it's the Commonwealth the prosecution team or the police team as well.
So, Mr. Gubitosi, the motion for exculpatory discovery.
Yes.
What is it that you object to in
I
there?
object to number 1C,
Okay.
number 1D, number 1H, I,
Okay, hold on.
and J.
C, D, H, I, and J.
And then that's on number 1.
Right.
Laura says, do you know what a Brady request is? A Brady request is a legal motion filed by a defense attorney to compel the prosecution to turn over exculpatory evidence that could prove a defendant's innocence or be favorable to the defense. This evidence, known as Brady material, is required by the Supreme Court's ruling in Brady versus Maryland, which established that the withholding of such evidence violates a defendant's constitutional due rights. The defendant makes this request because while prosecutors are legally obligated to disclose this evidence, there can be disputes what is considered favorable to the defense.
2, he wants me to certify in writing that I have made inquiry of every prosecutor in my office for all items and information favorable to the defense. I don't think I have an obligation to do that.
Right.
We did that on every single case. We do have a database. We do have a process. We do ask each individual officer these questions, but we do that on every single case in the county. That's thousands of cases to some 80 some odd prosecutors every day.
Well, and it doesn't include all of the prosecutors that have passed through the office that have come and gone over the course of the years. Are you suggesting, Mr. Bradel, that the Commonwealth needs to contact each and every prosecutor that has ever worked in the district attorney's office throughout the officer's tenure?
No, Judge, I'm not.
Well, that's what the motion asks for.
No, it doesn't, Judge. It asks them to have, maybe they could use a computer database. Maybe they can log, just like, you know, lawyers have record-keeping responsibilities. Lawyers have conflict checks. There's all sorts of things that are precedent for this kind of a thing. When a prosecutor has a case where some questionable police activity has arisen, prosecutors can easily document that in this case, Officer Jones was found to be not credible by Judge Smith.
Well, I understand that, but
Locked.
let me start with I. Whether the officer has signed a search warrant, I probably see 2 Frank's hearing requests a month in this session, 2 or 3.
This judge, by the way, he's like he defends a bunch of police officers, right? Or he's worked, I don't remember if I heard something with him being basically for Martha Coakley's helping out and she's a former master. Oh, is that who's sitting next to him, Laura? I don't know who Martha is. I heard he's like a cop defender or whatever, but you know, Kelsey was a cop as well. I think what's happening here doesn't change that. Like she was sworn into it and she was practicing law enforcement. So that was her job. Which I think is a little messed up.
Most of them are not allowed. Occasionally they are. And just because there is a Frank's hearing does not mean that there was a finding that anyone gave any false information.
Sure.
So how would anyone determine that?
Well, Judge, again, these are record-keeping requests. And
But who keeps a database of that
so
for the last 10 years?
when you're a prosecutor in a district attorney's office and you finish a case, you're required to follow office procedures to close out the file.
Right.
And there's no reason why a prosecutor's office ought to exercise willful blindness about these issues.
So you feel that it's up to you to decide how the district attorney's office conducts its business?
It's
Dude.
up to me to decide.
Did you work in the Essex County DA's office?
Judge, I did not work in the
Okay,
Essex County
so
DA's office, but I do
From
know a
when,
little
sir,
bit about it.
what are you speaking
Whoa,
about when you
whoa.
say that this is how a DA's office ought to be conducting itself? What's the basis for that?
Judge, okay.
Oh shit.
I don't think it's an obscure proposition, Your Honor, that when a public agency such as the district attorney's office has to close out a case, that they have to comply with record-keeping obligations under the law,
But
under FOIA, under record-keeping for all sorts of things about what happened with the case.
Well, I understand, but Mr. Gubitosi has represented that he's gone back and searched. They have a process. I'm sure that he'll advise you as to what the process is. And if you want to critique the process, that's up to you. But in terms of them producing evidence that is in their possession, custody, and control, he can only produce what he can search for. And the fact that you disagree, maybe you do, with the way in which they keep records or the type of records that they keep is not an issue that I'm going to decide. I don't know of any case law that says that I'm the one, or you for that matter, to decide how the district attorney's office keeps records. And in fact, I'm not going to order anybody to retroactively go back and search records from, I don't know how long the officers who are witnesses in this case have been police officers in this county, but do you know, Mr. Gubitosi, off the top of your head?
I know one of them is 20-something years.
Yeah, so I'm not sure that I can ask them to search records they don't have, but there is whether the officer has ever attended or presented at a law enforcement training by the private vendor.
Judge, before we jump off of that one?
Yeah.
All the Commonwealth has to do is ask the officers. There was 4 officers that were at the scene.
Right.
They can ask 4 officers, were you ever involved in a Frank's hearing? There are ways to do this. We don't have to act like this is some obscure thing, Your Honor. This is exculpatory evidence. We have every right to all these things under Graham McFarland and under Brady.
What case says you have a right to find out whether any police officer on any case has ever refused to answer questions?
A police
What the actual F? Dude. What are they hiding?
officer in our case, Your Honor.
Shit.
No. In this case, what is the precedent? You've got to cite, where is the case or statute that says that a police department has to disclose to you or to anyone else when an officer declines to answer questions. There are a lot of reasons for that, I can assure you. And I'm not aware of any records that are kept of that. And I can assure you that it would never be admissible under any circumstances. So I'm having a hard time with the concept that the DA's office or the police department has to supply you with the fact that an officer 15 years ago declined to answer questions after a shooting at the scene, but 2 days later answered the questions, for example. Happens quite frequently. So I am reluctant to say, I doubt there's any police agency that keeps records like that. I don't know of any, but certainly the district attorney's office doesn't keep records like that.
Your Honor, I certainly am not telling you anything you don't know, but just put it out there on the record. When an officer takes the fifth, so to speak, it's been found that a truthful answer would incriminate them. So it's incriminating information.
Who's made that finding? That's an interesting concept, because I probably represented thousands of officers at interviews, and I yet to have or even hear of someone making a determination that that person had a Fifth Amendment privilege or not. My experience has been that the department offers people a rights form, and if the department has made or ascertained that the person has a self-incrimination right, far be it from a lawyer to question that when the prosecuting or investigating agency is doing that. So again,
It's built into the law of the Fifth Amendment, Your Honor, that you can only take the Fifth Amendment when a truthful answer will incriminate you.
that's assuming you're ordered to, and that's assuming that the order also encompasses the nuances presented by the state constitution, which requires transactional immunity to overcome it under Carney versus Springfield. So it's not as simple as you make it sound. But let's get back to the fundamental issue. Does the district...
Yeah, I agree. Tippy said that's the problem. He's biased. You have to state a case or a ruling from the past to support this. Dude.
Attorney's office keep records of any officers that have ever invoked their rights at any proceeding that the district attorney's office is aware of?
No.
Okay. And if, with regard to the police department, Mr. Bradel, I'm not aware of whether they keep records of that or not, but I am certainly familiar with the fact that even if that were true of a particular officer, it certainly is not admissible.
Judge, Graham McFarland has a whole host of things that are not admissible, or an optimistic defense counsel
Right.
might say not yet admissible, but that's not a exclusionary factor, Your Honor. So you can't really go there. And these are all, we don't need to pretend like the officers are in Alaska. They're down the street.
No, I
The
understand.
Commonwealth can ask them all these things.
But does that case say that all records pertaining to an officer, any officer who has ever invoked his or her rights, either under the Fifth Amendment or Article 12, records have to be kept and they have to be disclosed? Does the case address that?
It does not say anything about.
Does the case address whether or not an officer who is the subject of a pending internal affairs investigation unrelated to the matter that is before the court, that those records need to be produced?
Yes.
Okay. And what about whether the officer has ever testified in a motion to suppress, which the motion was allowed because the officer violated? It's pretty broad in terms of violating the defendant's rights, but assuming we could refine it a little bit,
Sure.
does the case say that you must produce that? And who's charged with keeping those records?
Your Honor, Brady says we have to produce that. The Constitution says we have to.
On any motion to suppress that was ever allowed?
If an officer is found to be not credible,
Well, see, we're talking.
Well, hold on, those are two different things here.
Wow.
The fact that a motion to suppress is allowed does not necessarily mean that an officer was found to have lied or made false statements. There are two different things. People make mistakes. The purpose of the exclusionary rule is to deter police conduct, but
Police officers lying is not a mistake.
not every motion to suppress is allowed because a judge finds that an officer lied. Yes, the motions are allowed because in the court's judgment, For example, a stop was unjustified, but that doesn't mean that the court found that an officer lied. In fact, I'd say most of the time that's not the case.
We're not talking about a legal ruling about an officer's conduct. We're talking about when an officer's been found not credible. And that's what we're looking for, Judge.
Well, does your office keep records of decisions by judges saying that officers made false statements or are not credible?
Yes.
Okay.
And so,
Yeah.
and you think
Ew.
what he's writing in this motion is much different than what he's saying here.
Did you check the database for what I just
Yes,
outlined?
and we asked these officers, and he knows this, we asked these officers a whole host of questions.
Okay.
About whether they have convictions, admissions to sufficient facts about criminal offenses, and I'll just adverse credibility findings against them from any court.
Okay.
Pending criminal investigations into your conduct, findings that you have engaged in bias, racial, or
Okay.
profiling, discrimination.
Okay.
Of any kind. Findings that you have engaged in untruthfulness or other misconduct implicating credibility.
And have those questions been asked of the witnesses in this case?
Yes.
And have you
I
provided?
do think information from those 4 cops that were there or whatever police officers that were there, law enforcement, I think they should be able to get everything like because he's asking for evidence or not evidence, I guess, but he's wondering who's like been lied before, right? Or who's refused to provide statement from before, but I'm assuming he's meaning the cops that were there. I'm not a lawyer, but
Any information that's responsive to those questions?
There's
So what's the complaint, Mr. Brady?
and they have no body camera, which I talked about this in the last Kelsey Live. I'm blown away that, I guess it's like a state fund kind of thing, but I think that's bullshit. And I think every law enforcement officer should be wearing body cam and have it on at all times.
Well, that's what I'm asking, is if it's complied with, and
You just said it was.
saying it was, and counsel got up and seemed to be wanting to correct me on that, and so here we are.
Okay.
So is it complied with or
Well, it's on
not?
the record. What else do you want?
The motion speaks for itself, Your Honor. I
What
just want to know what the
the?
Commonwealth
I just find his tone really rude.
is objecting to.
Well, Mr.
They gave us a list, and we can go through it.
The list of questions that you asked?
Counsel objected to 2C. Have they ever refused to answer questions citing their constitutional rights? We had a little bit of a debate about that. I think that's, Judge, a firing offense. I believe that assistant attorneys general have been fired for that. I believe officers have been fired for taking the fifth.
Really?
I think it's
In the absence of
exculpatory.
transactional immunity, officers have been fired?
I think it's
You should read
exculpatory.
Carney versus Springfield, and I think you'll find that you're incorrect.
Well, Judge, I think that an officer that takes the fifth in this case about something else is saying, if I answer that question, a truthful answer will incriminate me. So I
Well-
think under Graham McFarland, I think that's certainly
The case doesn't say
exculpatory and
it.
discoverable.
The case doesn't say it. I don't agree with you. Carney versus Springfield says otherwise, okay? And I don't agree. So, Mr. Gubitosi, have you provided a list of the questions that you have asked to the officer, or can you, or will you, provide the list of questions that you ask to defense counsel?
Of course.
Okay. And Mr. Bradel, if the answer to all of those questions is no, and they've asked them, I'm not seeing anything that would indicate otherwise in this case, then you need to examine the questions, and if you feel there's something that wasn't covered, then you can refine your motion. But I am not going to allow, and I don't think I agree with your view of the law, that whether or not an officer is refused to answer questions, citing constitutional rights is something that you're entitled to. In the immediate aftermath of critical incidents, officers often advantage themselves of the fact that the police department does not have transactional immunity so that they can have an opportunity to speak, sometimes within 24 or 48 hours. Happens all the time. And in fact, officers are often interviewed thoroughly thereafter. So the case does not say that if you refuse to answer questions, it is fireable. In fact, it says quite the contrary. The police department does not have the ability to grant transactional immunity. Only the Commonwealth of Massachusetts, the district attorney's office, or the attorney generals have that ability So to suggest that a chief of police or commissioner could fire someone for invoking their rights without giving them transactional immunity is incorrect. And so as to the extent you're asking for that, it's denied. Now,
The next one is D.
yeah,
Wow.
Whether the officer is subject of a pending internal affairs investigation or any internal affairs investigations into the officer's conduct, whether these have resulted in sustained findings of misconduct. I'm not sure why there's an objection there.
Well, the way it reads is different than the way he says it.
Okay.
If there is a sustained finding, absolutely.
sure,
And,
okay,
and there hasn't been in this case. Or
Okay.
With any of the officers that are involved.
okay. So that's the answer to that. And as far as the other questions, it seems to me H and I are covered by the questionnaire, but J,
Well, no, if I might just say, H and I, if you're going to deny them, but they're different than what he's saying.
no, I is only, you only need to respond to I if there's been a finding by a judge that there was a misstatement in the search warrant affidavit, not whether or not defense counsel has filed a Frank's motion, because that happens routinely, and routinely the matters don't even reach an evidentiary hearing. And even if they do, it often doesn't result in a finding that there was any untruthfulness. So yes, if there has been a Frank's finding by a judge that an officer, any of these officers, made false statements in a search warrant affidavit, yes, you've asked about that, and yes, that has to be produced.
Of course.
Okay.
But H, if we can just get back to that.
Yeah.
Because we talked about that a little. And if the way counsel is talking about it, if there's been an adverse finding of credibility, of course we turn that.
Yes.
That's a no-brainer.
Right.
We do that.
But-
But that's not what that said.
No, not every, I am not going to order the production of any
Wow.
motions to suppress that were allowed for any reason. First of all, it's almost impossible to ascertain that. And secondly, how many district courts in this county, Mr. Gubitosi?
7.
7? Well,
Yeah, but you can ask the officer, Your Honor. The
well,
officer is
he
right
has,
there. You can
and if
say-
there, I agree with you. If there was a finding that the officer made a false statement, you're entitled to that. But the fact that an officer thought that he or she had reasonable suspicion to conduct a pat frisk and a judge disagrees does not mean that the officer was found to be untruthful. But
I
yes,
agree with you. We don't
in the
need to-
course
we
of,
don't need to debate it. I agree with you.
okay, so I think we're fine. Now, Jay, you know,
I just have no idea what that
I have no idea what,
This case is complicated because there was no body cameras. And I think when someone is being charged for murder and there's no body cameras, I think that should matter. How would you like to be set up and charged with murder or accused of murder and you have no proof to back it up and you're telling the truth, but they don't have body cameras? I mean, I don't think that's necessarily fair. Sure, are the police officers people of power and work in law enforcement? Sure, but just because you're a cop doesn't mean you're person of freaking God and you're perfect and you don't lie. People lie, police are corrupt. I don't know if you guys have experienced that ever in your life, but I have actually been in many lawsuits regarding criminal stuff. So I do believe police are corrupt. We saw it in the Karen Reed case. Do I think she's guilty? Now, we weren't there. We don't know. Nobody knows except her and that cop. But I think everything should be put out on the table, of course, 1000%, so that everything can be known. But then again, no body cams. So how can we blame someone and accuse someone if there's no proof of anything other than people being shot and in the hospital? Police are corrupt, especially in Massachusetts.
that is.
Okay, and then they can answer that. They don't know about it, they don't know about it. That's the answer. I'm happy with that.
Okay. Now, is there, Mr. Gubitosi, when did you get meeting 35, the motion for specific discovery?
Friday.
Okay. Are you prepared to respond to it?
I can try to do that.
Okay. Is there anything in there that you object to?
Yes.
Okay, and what is that?
Yeah, exactly, Laura. That's kind of what I was getting at. The other cop shot her. He could be lying to protect himself. Wouldn't you? Would you guys do the same to protect yourself? I mean, be for real. Then she could be lying also. Exactly. She should not be in jail. No. This much I know. She needs a fair trial. Yeah, what's a fair trial in a place where everyone's corrupt? The courts. And after the Karen Reed case, amongst a few others, I question a lot of what happens in the courtrooms and the police officers. I really do. Um, Now, the Karen Reed's a whole nother thing, right? And what we think of Karen Reed is way different. But police officers do lie, is what I was getting at.
Again, there are portions of number 2.
The other cops were there too. Yeah, the other cops were downstairs. So really, it's what Kelsey's saying and her friend who shot her. He said, she said. If it can't be proven what happened in that room, then I think charges should be downgraded. And I think she should be out on whatever they had her on, ankle monitor or whatever.
The Commonwealth will provide all witness statements.
Okay.
As pursuant to Rule 14, just as is overbroad.
Okay.
Number 4A, excuse me, 4, is asking for any and all footage from the North Andover Police Department on June 30th during the time of which Ms. Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But
Wait. Did you guys hear that? The footage is gone. Where have you seen that? Where has footage disappeared recently in a case out of the Commonwealth? The one I was just talking about, Karen Reed. How does footage disappear? My ass, it disappears. Like, doesn't disappear by itself. I'm gonna reward. Hi, Skyla. Good to see you, girl. I'm going to rewind because he just said the footage is How does it disappear? I'm sus. This is why I'm sus on this case. Let's go back.
number 4A, excuse me, 4, is asking for any and all footage from the North Andover Police Department on June 30th.
Any and all footage from the North Andover Police Department on June 30th, and it's disappeared.
During the time of which Ms. Fitzsimmons was at the station. And we've already talked about that. They asked me a bit ago. They didn't ask me in time, so the footage is gone. But it just doesn't save longer than, I think it was 30 days. But
Okay.
It doesn't save longer than 30 days. So how do we get all this body cam that we were watching last night and stuff? Is that really true that everything deletes after 30 days? I really don't believe that. Someone deleted that.
If something doesn't exist, then,
But the last paragraph, the last sentence says, the name and contact information of any officer that interacted or observed Ms. Fitzsimmons at the time.
okay,
Well, she has that information. Who she interacted with on
Right.
November 30th of 2025 at the station, so that's something.
well,
that-
first of all, maybe I'm missing something.
Okay, I'm done with this like hearing really because after hearing that, really, footage disappears. I would just like to know how that disappears. And then he says, oh, it gets erased. So which is it? Did it disappear by itself or did it get erased? I don't think it's the same thing, really. It's gone, is the conclusion of that. I didn't know that. So after a cop shot another cop, they don't think to save it. Exactly my point. Calissa says that's a complete lie. Do they have backup files? They should have backup files. To the cloud, I don't like the cloud.
But other than in the interview room, when someone's advised that they're being recorded and you know, they're taped,
I'm not sure there's,
No, I think this is, she didn't go to the PD after the event. She went to the hospital.
Okay.
Before the event, it's my understanding, and this is only from what defense counsel told me,
Yeah.
that she was at the station earlier that day.
oh,
She
okay.
had done something, I can't remember what, during the day.
Was that the station earlier, Mr.
But she
Bradel?
knows who she interacted with.
Okay, is June 30th the date of the incident, by the way? Okay. And when was she at the station and for what purpose? What time does the incident happen?
So Your Honor, the incident is, it's in the afternoon of the
Yeah.
30th, and prior to that, Ms. Fitzsimmons was at the North Andover Police Department for a CPR recertification.
I see.
She brought the baby with her.
Okay,
So we wanted the video
Yeah.
from the station.
Yeah.
And on,
They don't have that. They don't have her entering and walking down the hallways in the station doing a CPR class. Melly, I've been wanting to watch this with you. All the local. Oh, thank you, Laura. Yeah, I'm angry.
August 26th.
Not
I
at
think
you.
the council's going to have an issue with this, okay? On August 26th, we filed these arraignment motions.
Right.
Asking, we put them in abeyance except for some of the more obvious ones like
Right.
preserve notes, preserve video.
sure.
Tell people who are video holders to hold on to the video. That was August 26th. So the Commonwealth was on
You
notice.
guys, this was June 30th, and we're November 26th. That's like 4 to 5 months. It's not like this happened in 1811 and they want the footage. Like, well, there's probably no cameras back then, but you get what I'm saying. It wasn't like it was that long ago. They should have that footage.
As of August 26th.
Yep.
The video, I am fairly certain, was present and available then, when they were given notice of this motion, and I believe the court allowed those preliminary requests.
Well, there are two issues there. First of all, though, when you say August 26th, was that filed in this court
Correct.
when she was arraigned?
Yes.
Okay. And Mr. Gubitosi, do you know, first of all, I don't know, because not that familiar with the North Andover police station, whether or not they even have cameras that would have videoed the presence of the defendant at the station on that day.
Yes.
Okay. And
They
do you
do.
know how often those are recorded over?
No.
Not at the present time.
Okay.
I did. When we spoke about it, I called.
Back in August?
It was on, I can't remember.
Okay, okay. So the issue then becomes whether or not the request was made. First issue is whether or not you're confident the video doesn't exist today.
Correct.
Okay. The first question is,
He's confident it doesn't exist. I agree with you, Evie. Selective evidence. This is ridiculous.
I think that the defense counsel is entitled to know when the video, how often they tape over. I mean, I hear,
I did tell him that.
Right.
When I found out, I just can't remember right now.
but you can,
I can just suggest, Judge, if
Yeah.
I may.
Yeah.
I looked at, counsel's trying to accommodate, so I
Right.
appreciate that. But on 9/18, counsel told me that they only had it back to July 5th.
okay. And you made the request on,
So the footage this happened on June 30th. So they already knew that it was there. It was there. The footage was there.
26.
right, but that doesn't answer the last question, which is whether or not at the time you made the request, it still existed or not.
Right.
But Mr. Gubitosi, that should be easily ascertained.
Absolutely.
Sure,
I
okay.
think if you do the math, it looks like it is, and again, I
Is-
appreciate the Commonwealth's efforts to try to get it, but it looks like on
Yeah.
8/26, if you do the same math, 9/18, it goes back to July 5th, 8/26, you're going to be within the window of.
You may, I don't know. I don't have, every video system that I've ever heard of, I've seen some that go 3 days, 7 days, 30 days, I don't know. But that's easily ascertainable, and Mr. Gubitosi is going to tell you about it, and then you can make of it what you need to make of it.
And there's no motion before the court on
Yeah.
it. I just wanted to
Okay.
bring it up, Your Honor, that it's very
The judge's demeanor changed after that came out.
important to the defense that we have that
All right.
video.
Anything else we can, in this motion, Mr. Gubitosi, that you object to, that we can address today?
Yes, I could just have a second.
Please, yeah.
Number 6 is concerning disciplinary records for firefighters that responded to the home address of the defendant or Mass General Hospital.
And your objection to that is?
So the firefighters are not part of the prosecution team. If they're not in care, custody, and control of the file.
I mean, you can file a Rule 17 for that, Mr.
Very good, Your Honor, that's perfectly
Radel. I
fine.
think that's right. What else, Mr. Gubitosi? Anything else in this motion?
Number 9.
Yep.
All statements, including text, emails, voicemails, writings, or like between or among any civilian witnesses.
You guys want to know why they want that footage, right? Did you guys catch it or no? Because they want to see who was there. They want to see what time her ex was at the police station and what time he left and etc. to the time of the event that occurred.
Prosecutors. I would just say it's
Because it'll prove if the ex went to the house prior to the warrant or restraining order being served to her, because then that shows what it shows that they were already planning on doing this and that Justin waited down the street or whatever. So I think they're trying to establish like a timeline of that. Came to the court and she said she attacked him. So she was going to, I believe, do something to him and the baby and got a temporary restraining order. That's how it all started. Yeah.
it's overbroad.
Yeah, how?
At least that's my
How can
opinion.
the Commonwealth?
I'm not a lawyer. I'm not any of these people, but I think that that's what they're trying to establish. Like, he told her to go to the park and wait for him. She was at the goddamn park with the baby for hours. Yeah, while he was what? Already at the house? With the police or what?
Produce messages between people who are not, civilian witnesses.
Sure, I understand.
That
Your
makes
Honor.
sense.
The request should be really a little narrower, I suppose, which is,
They're saying he was at the court, but wasn't he at the house too before she got there? Justin? We're going to read the court document because I don't remember everything on the affidavit. I might be wrong on some of this.
whenever there's a police prosecution team member in the conversation,
Well,
then
that's
it should
different. I
be
agree.
discoverable.
Right.
So
Statements, Mr. Gubitosi, of people who are,
For statements that
yeah.
I'm obligated to provide in Rule
Yeah.
14, absolutely.
Okay.
I agree with that,
Okay.
but not that.
And just, oh, sorry, good.
Yeah.
Go ahead, Counsel.
No, I was moving on.
Just the one thing on that before you move on, Your Honor,
Yeah,
is
sure.
that,
Yeah.
it's our view, we viewed on the security video from the scene that officers are texting and calling all over the place at the scene, quite understandably.
Sure.
But we just want the text messages, and we have information that there were communications between the father of the child and the police officers leading up to serving this warrant, leaving up the restraining order, rather,
I think that's fair. We should see the text messages, all of them.
serving the restraining order, leading up to that. And there are communications that are between the father and the
Okay.
police that we want,
well, if
which would
any
certainly
of
be
those
statements.
materials that are in the possession, custody, or control of the Commonwealth or the North Andover Police Department need to be produced. I can't, it's a little bit broad in the sense that, if there are people texting,
That's a good point, Laura. You bring up Proctor because those Proctor texts were everything.
that the Commonwealth doesn't know about. it's
I
kind of hard.
agree, Judge. I don't even want to, yeah, I can cut to the chase on that.
Let me
Statements
suggest
that involve the
something
police and prosecution team.
here. I'm well aware of the fact that there's some discovery issues here, but they don't seem insurmountable to me, and they seem like something that could be worked out. The defendant's in custody. You are and have, as is your right, litigating the issue of her detention. And my solution to that, it's not my decision one way or the other, but it's in front of the SJC. But I feel that this is the type of case that is tried in the district court every day. It's a serious case. All cases are serious, but it's not complicated. And I want to set a trial date sometime early next year, and we'll get another discovery compliance date in a few weeks. Mr. Gubitosi starting a trial December 1st. So maybe in late December, we can have another compliance date if it works for everybody to try to iron these things out, because, she is in custody. I'm cognizant of that. And so my solution, whenever, and we deal with this all the time, we spend sometimes more time dealing with the issues of pretrial conditions and release. And in the time we spend doing that, we could try the case. So this case looks to me, and I could be wrong, that it could be tried in a couple of days. And she's in custody. So if the case is tried and she's found not guilty, that's the end of it. If the case is tried and she's found guilty, that's a whole other issue. But the fairest thing, it seems to me, is to try the case as promptly as we can. So before your schedules get any more backed up, I want to set a trial date. We can always revisit it, but what about sometime in late January, February?
That's very fair, Your Honor, and I appreciate you saying that. And I wanted to ask maybe the first week of February.
Sure. Mr. Gubitosi, how's that work for you?
I have a murder starting on the 26th of January, so if we can go to, I could do this the week of the 9th.
Okay.
That's fine.
Does that work for you, Mr. Braden?
Yes.
Ms. Attorney Coakley?
Always with the caveat that I haven't checked with any witnesses.
Of course.
Sure.
And but this way we have a target date. Everybody can check with their witnesses. We can find out and iron that problem out now. And if there's somebody who needs an adjustment for a few days, a week, one way or the other, we can work on that. But the longer we wait to do it, the more backed up we get. And again, we're going to prioritize this case. She's in custody. Maybe she will be at that time, maybe not. I don't know. But at best, for your client, she's going to be on restrictive conditions, and that's a factor as well. So let's get a trial date now. Let's shoot for that. We'll schedule it for trial on February 9th. I think that's very reasonable. And let's set another discovery compliance date that everybody can live with. Sometime in December. Mr. Gubitosi, you expect to be tied up for a couple of weeks?
Yep, I think I can, the week of the 15th, I should be.
Okay.
I was going to ask for maybe the 18th along those lines. I think we're in the same
That's
process.
We can do that, sure. We'll do the 18th. And my purpose that day,
Sorry, Judge, it's a calendar issue, I'm sorry.
okay, all right.
Judge, 18 is a tough day, it turns out. Could we do the 19th?
I'll do it.
Okay.
If Mr. Gubitosi's available, okay. We'll do it. Now, and I want you to have a conference, which I know you will, to see if you can work these things out or refine or narrow the motion, and we'll revisit those things that day. I have a Zoom that's coming from a different Norfolk that we have to get to right now. So it's either that or we get together late this afternoon.
Perfectly fine, Your Honor.
Okay.
I think we can resolve much of the rest of it.
Now, as far as your request, the last thing I'm going to cover is your request regarding transportation of the defendant. I allowed it today. I'm going to do it on a date-by-date basis. I mean, if the next date is discovery motions, I don't think that it's necessary to transport her. If you want us to try to do a Zoom, we'll attempt to do it. But the goal here, again, in fairness to the defendant and everyone else, is to get the case tried promptly. So we'll have a hearing that day. I'll try to, or me or someone will iron out all of these issues if we can, and let's keep moving. I don't expect, doesn't sound like you intend to litigate a motion to suppress in this case.
Correct, Your Honor.
So that removes one common obstacle to getting this done. So working with that, I think everybody's being reasonable in terms of time. Why don't you have a further conference, exchange written responses so that there's, down the road, there's no misinterpretation, and let's see each other again in a few weeks. And I'll order a Zoom, Habe, if we can do that.
Thank you, Your Honor.
Okay? All right.
I think that'll be fine. If there's any issue, we'll file appropriate date.
And if you have a narrower motion, or you can narrow the issues, file another motion, and I'll make sure that I get a look at it, or somebody will.
Thank you, Your Honor.
All right, thank you. Have a great holiday. All right,
Thank you, same to you.
okay.
Judge, would that be at 12 noon as well, the same thing, or does that?
My boss has to tell me that right here.
She said, I love you to someone.
Okay, she says noon, then we'll do it. Okay.
Welcome to Zoom.
So trial, that is not very far away. Now he's gonna dig around and not transport her. Like, why can't they put her in a effing van? I know, I don't understand that part. Let's get through some of these documents. Yeah, I don't understand that. Yeah, I was gonna dig into those later, Laura. Meanwhile, she's not seeing her baby at all. I don't understand why she can't at least have visitation with her baby. I agree. I'm thinking they have something on her. How can they hold her? The rumor of other witnesses other than hubby must be true. Yeah, I want to hear from those witnesses too. We might watch that. I think I might have saved it. So an appeal, November 2025. I don't know how much, like what's on these, but I wanted to just kind of go through them. Criminal docket, assault to murder, armed, assault with dangerous weapon, assault with dangerous weapon. It's just like docket paperwork and stuff, and then there's a few documents in here. I just want to make sure we don't miss anything. Okay, hearing stuff. Here's a statement. I think I've read this before, but we're going to go through it again. This is a restraining order or whatever, affidavit that Justin, a lion, sorry, not alien, a lion, filed June 28th. Kelsey Fitzsimmons is a danger to myself and our son, along with herself. On Saturday night, June 28th, Kelsey struck me with a closed fist. Hold on, I lost my spot. Struck me with a closed fist 3 times to my face. I was scared she would not stop. My brother and sister heard noises and knocked. I was able to open the door, and she grabbed my arm and ripped me back into the room. My brother and sister came in, and she said she didn't do anything. I feared for my life, so I left with a friend to stay at a hotel. Family and her closest friends reported that even after I left, she physically hit them to try to get to me. Her friends called the Bethel police in Maine and North Andover police and MA because they thought she might try to hurt herself, the baby, or me. Kelsey decided, sorry, I'm trying to read his writing. Kelsey decided to, I can't read that, to whatever while heavily intoxicated and fighting with her friends, that she would leave to get the baby. Her parents took our son from my parents in the middle of the night, saying they didn't care what manic state she was in. They were taking the baby to her. Today, Kelsey is threatening to take the baby far, far away for a long time, quote unquote, is what he said. This is how she has spoken about killing herself in the past. I fear that she will unalive the baby at any moment. She punched her stomach repeatedly while pregnant, saying she would unalive herself and the baby. She has on several occasions struck me with her hands or feet. I fear if she does not have me, she will unalive the baby because she has said nothing besides me is worth living for. Okay, chill out, Justin. Like, you're not that hot. Chill out. Like, did she really say that? In March 2025, she was sentenced by Lawrence General Hospital. This is an ongoing safety concern. They were at their bachelorette party. True crime, she's being held over for dangerous hearing and then released. Then she couldn't go back into the scrum. Yeah. She's not being held because of her charges. Oh, I didn't see the rest of that. So this is the MSP offense report from July 30th. Arrest warrant for Kelsey Fitzsimmons, June 30th. Interesting. They didn't put any time on this. That's weird. Dissemination code report respect the security of its associated cases. Crime scene number 1, Phillip Brooks Road. Location occurred, Phillip Brooks Road. Assault, 3 charges, 3 felonies. Victim number 1, Patrick Noonan, 49-year-old male. Victim of completed felony assault to murder. He's the one that got shot by her. Or that she thought that she pointed her gun at. That he said, basically the guy that shot her. Relationship unknown. I thought they were besties. Not besties, but friends. Suspect number 1, Kelsey Fitzsimmons. Okay, 28 years old. Gunshot wound, admitted to hospital. Arrest number 1, Kelsey Fitzsimmons. Let's read this probable cause. On June 30th, 2025, at approximately 1900 hours, I was notified of an officer-involved shooting by Trooper Cameron Ortiz. I learned the incident occurred inside of 125 Phillips Brook Road in North Andover. Trooper Ortiz reported that a female party, later identified as Kelsey Fitzsimmons, was being transported to Mass General Hospital in Boston with at least 1 gunshot wound to her chest. At that point, I responded to the scene along with her other members of the Essex County State Police Detectives Unit, Mass State Police, and Firearms Identification Unit. Yeah, they should all be all of these people involved should all the evidence and whatever they have or whatever you call it, text messages, all of that should be, I think we should see everything. I arrived on scene at 125 Phillip Brooks Road and was briefed on the incident by Lieutenant Sean Daly. I learned that Fitzsimmons is a North Andover police officer who's currently on leave. Fitzsimmons resides on Phillip Brooks Road with her fiance, identified as Justin, and their 4-month-old infant. On June 30th, 2025, Justin sought and was granted an abuse prevention order at a Essex Probate and Family Court. Justin alleged that Fitzsimmons physically assaulted him over the weekend and that he was in fear of her. He stated that Fitzsimmons had assaulted him in the past. Justin also stated that he feared Fitzsimmons would hurt the infant if he were to leave her. Okay, is there proof of that? Like, I need to hear from the family. Like, did they see them fighting, putting hands on each other? Like, did he videotape her? You remember how the Johnny Depp case and Amber Heard, like they were like videotaping each other fighting and stuff? Like, is there that stuff? Because I need to see it. Serious question, why is everyone so critical? Has he been proven to be a liar? Am I missing something? Mm, not necessarily a liar. Tasha, I'm actually trying to keep an open mind. I'm not super against him. I think I'm like more against, I'm somewhat against him, but I'm more against like, I guess a police department. I'm like, I have a problem with like the body cam and the guy who was her really close friend, what he's saying. And I only know that because people have lied on me before to the police. So it's, we're human. I don't know. I do believe she was drunk at the bachelorette party. I believe she was drunk. She's not being held because of her charges. She was released. The hearing we watched when the judge put her back in jail because, yeah, of the scram. Um, but again, was that necessary? Because she could have done other forms of testing. We talked this on the last live. That she used to drink heavily. Her own friend said she was out of control and saying allegedly, but others say the hubby was cheating. Yeah, I want to see the evidence. Approximately 1802, Lieutenant Daley, Officer Noonan, and Timothy Houston from the North Andover Police Department responded to 125 Phillips Brooks Road to serve Fitzsimmons with a restraining order. Along with serving the order, these officers intended to remove all firearms from the residence as part of the court order. Additionally, the court ordered the custody of the 4-month-old infant was to be awarded to Justin. Lieutenant Daley advised Fitzsimmons of the order and that Justin would be obtaining custody of the infant. Approximately 10 minutes after the police officers arrived at the residence, Justin was called to come and gather his belongings and take custody of the infant. And if she was violent with him before and whatnot, like, why didn't he effing report it? He's a police officer. Like, I'm sure he could have done something about it. In and now we can't go into like, oh, victims don't want to report it. There's no proof here that she was beating him like Amber Heard allegedly was beating Johnny Depp. I keep going back to that because that's a case where a man came and spoke out. And so, yeah, it's he said, she said at this point, in my opinion. In anticipation of Justin taking custody of the infant, Fitzsimmons began to gather items, clothing, diapers, and bottles for the baby from around the house. Officers Houston and Noonan escorted Fitzsimmons through the house. After gathering bottles and diapers on the first floor, the officers escorted Fitzsimmons to the second floor so that she could gather clothes. Oh, okay, they put cloths to gather clothes for the baby. During this approximate time period, Justin, as well as Fitzsimmons' mother, arrive at the house. When Fitzsimmons became aware that Justin was at the house, she asked Officer Houston to keep Justin away from her. Officer Houston, in an effort to maintain order, left Fitzsimmons and Officer Noonan on the second floor and went to monitor Justin as he gathered his belongings in the basement. So yeah, only them two were in the room. Lieutenant Daley, who was interviewed on July 2nd, stated that he remained on the first floor of the house with Fitzsimmons' mother and Justin and Officer Houston. He stated he heard Officer Noonan on the second floor yell, "Kelsey, don't do it. Kelsey, don't do it," followed by 2 gunshots. All officers began to render first aid to Fitzsimmons and requested an ambulance to the scene. While administering aid to Fitzsimmons, Lieutenant Daley stated that he observed a firearm where Fitzsimmons was lying. He moved the firearm to the bed out of reach of Fitzsimmons. After the incident, while medics were treating her injuries, Lieutenant Daley said that Officer Noonan told him that prior to the shooting, Fitzsimmons had pointed a firearm at him. That is when Officer Noonan shot her. I mean, Melly, you don't really know there's not proof. I guess we don't yet, but they should show it. And if people are witnesses, then that they should be involved. But I guess, yeah, that's what we'll see from, I wonder who, so like everybody maybe at the bachelorette party, family members would be witnesses, police officers. To be fair, yeah, we do have to wait to hear from the people at the party for sure. Um, I think too, like, could it have just been like an accident? Like, could he have maybe thought she was gonna shoot him, but she was actually like pulling the gun out to shoot herself or pointing it at herself, and he maybe just assumed it and made a mistake, and he doesn't want to admit that he made a mistake because he would be held accountable to some extent. I mean, they both were in a very traumatic situation the year prior involving a case of a mother unaliving herself and baby. So could it maybe been like a trigger also? On July 30th, 2025, Detective Lieutenant DeMio and I interviewed Officer Timothy Houston at North Andover Police Department. Officer Houston provided a similar account of the incident as Lieutenant Daly. Officer Houston stated that Fitzsimmons told the officers that all her firearms were locked in a safe in the basement. Officer Houston stated that Justin arrived at the residence when Fitzsimmons was packing her belongings. Fitzsimmons stated that she did not want Justin in the residence while she was there. Officer Houston went towards the basement to advise Justin to wait downstairs. Moments later, Officer Houston heard Noonan scream, "Kelsey," followed by 2 gunshots. Officer Houston immediately ran upstairs and observed Fitzsimmons lying on the ground. Officer Houston asked Officer Noonan what happened, and Officer Noonan stated that Fitzsimmons pointed the firearm at her, pulled a trigger, and then racked a round of ammunition. After the shooting, all of the officers began to render aid to Fitzsimmons. On July 30th, Detective Lieutenant Demieux and I interviewed Officer Noonan at the police department. Officer Noonan provided a statement that was consistent with the timeline of events provided by Lieutenant Daly and Officer Houston. During the restraining order service process, Officer Noonan was alone with Fitzsimmons on the second floor of the house. The second floor consisted of 2 bedrooms and a closet. Officer Noonan stated Fitzsimmons was packing clothing and books for the infant. Noonan stated that Fitzsimmons was kneeling on the ground folding laundry in her bedroom. Officer Noonan, standing in the doorway, observed Fitzsimmons facing towards him, lunge towards an area behind the door, and then reappear pointing a firearm directly at him. Officer Noonan said Fitzsimmons pulled the trigger and he heard the firearm click, but no round was fired. Fitzsimmons then began to stand up as Noonan pulled firearm out of his holster. Fitzsimmons began to rack the firearm to chamber a round. Officer Noonan gave several commands such as drop the gun and don't do it. Officer Noonan stated that at this point, he knew she was trying to unalive him. He fired 1 round and Fitzsimmons continued trying to chamber a round. Officer Noonan fired a second round, striking Fitzsimmons. Lieutenant Daly, Officer Noonan, and Officer Houston then began to render aid to Fitzsimmons and requested EMS to the scene. Officer Noonan stated that Officer Steve Core arrived at the scene after the shooting as a 4th officer. Officer Core made Fitzsimmons' firearm safe by removing the magazine. He reported that there was a round of ammunition in the firearm. He then placed the firearm in a safe. A search warrant was executed at the residence and 4 semi-automatic firearms were seized. Arrest, Kelsey Fitzsimmons. Okay, I think we already seen that part. Let's see, what else is here? Findings and order, motion for detention. I can't even read this person's writing. Defendant's record of conviction, 0. The defendant is on release pending sentence or appeal for any conviction. Physical condition, dysfunction. Severe state of emotional, oh, I see. I can't read that. Additional findings. Placed on admin leave. Violent content, 6 June 2025 of alleged attacked fiance physically, which we just read about. Obtained RO infant child protection order was replaced and served. Okay, this is blank. In the matter of Kelsey Fitzsimmons, assault to murder armed, attorney information. This is the docket. Superior Court bail pursuant. Did we read this? I don't think we did. Now comes Miss Kelsey Fitzsimmons, defendant, and hereby, okay. The instant appeal is based on new medical information and obtained in the past 2 days that she is not a danger to herself or others and will benefit from a release plan and based on other additional information. I think we did read this one. Ms. Fitzsimmons appeals the 58 finding and requests that the legislative presumption of personal recognizance in the bail statute be applied. Alternatively, Ms. Fitzsimmons moves for terms of release by agreement under Section 87 of the bail statute and proposes herein specific comprehensive terms of release as set forth by Mass General Hospital. Ms. Fitzsimmons brings a motion pursuant to the U.S. Constitution and the common law of Mass and moves that the court hear the additional evidence, set bail, and vacate the 58 order in favor of Section 58 or Section 87 order of release terms by agreement. As established below, there are no risks associated with Ms. Fitzsimmons returning to court, and she is medically cleared from being a danger to herself or others. So that's a little confusing because she was cleared. Under the de novo provisions for bail appeal, this court is entirely free to consider the circumstances and revise the bail determination to either personal recognizance or agreed terms under Section 87. Release will allow Ms. Fitzsimmons to further demonstrate to the court that she's healthy, strong, and worthy of the court's decision. I mean, her being like cleared and stuff, so she was like mentally, emotionally cleared to go back to work. But then what about like the mental health issues she was experiencing? I guess I'm a little confused about that. Why she was cleared? Dr. Paul Ziesel's finding. Ms. Fitzsimmons had been meeting with Dr. Paul Ziesel over the past several weeks in person as she recovers from a gunshot wound to the chest suffered on June 30th. His summary of Kelsey's situation is, quote unquote, my clinical evaluations with Ms. Fitzsimmons reveal a deeply caring mother who, under an unimaginable confluence of stressors, experienced an acute, transient psychological crisis. It is my professional opinion to a reasonable degree of psychological certainty that Ms. Fitzsimmons poses no credible risk of harm to herself or others, that her reunification with her 5-month-old son Caden is a matter of clinical and developmental imperative. Dr. Ziesel details the basis for his findings in his report filed for the court's consideration. Hey, Mary Beth, good to see you. There's no door in that bedroom. I think I heard that. Anything filed before actual evidence is presented is essentially just he said, she said. I do wonder why she wasn't granted supervision, though. Good question. But people are saying maybe one of them is the woman he was cheating with. That's wild. The district court's findings and the new information for a proposed release plan. On July 7th, the court found no conditions of release could assure the safety of individuals and held Ms. Fitzsimmons. The court noted the lack of a specific written release plan from the hospital. Since that ruling, such a plan has been prescribed by the hospital over this past weekend, wherein she has been found to not be a danger to herself or others by reasons of mental illness, and that she does not fit the criteria for Section 12 commitment, which is Section 12 means involuntary commitment authorized where clinician has reason to believe that failure to hospitalize such person would create a likelihood of serious harm by reason of mental illness. The hospital clinician, the head of a 3-person team, including another doctor and a licensed social worker, recommends a release plan. And this is what they said. Appropriate for outpatient care once medically stabilized or discharged. This will specifically include establishment and ongoing engagement with individual psychiatry and counseling. one-on-one weekly therapy, as well as a step down to partial hospitalization level of care once discharged to the community home setting. Our team will work with the patient and hospital psychiatry case management to ensure that these resources are in place prior to discharge. The patient has been in full agreement with the above outlined plan. Ms. Fitzsimmons is not a danger to herself or others, as found by the MGH team and also independently by Dr. Ziesel. The court should endorse this determination and consequently release her on personal recognizance or agreed terms under Section 87 that incorporate the above plan. She has been found by her expert clinicians to not be in danger and deserving of release. This is an older document. We read the most recent one, but I had to take that live down. Ms. Fitzsimmons emphatically denies pointing a GUN at the officers. She recently released a statement strongly denying these charges filed herewith. The only evidence to the contrary is the complaint officer's sole word that this happened. I have to sneeze. Excuse me. Okay. I needed to sneeze. He needs to be charged with manipulating the system and BS charges. Ms. Fitzsimmons emphatic. Oh, shoot. Sorry. I just closed out of the document. Dang it. I need to zoom in. He was the only person. Okay, the only evidence is a contrary complaint. The officer's sole word that this happened. He was the only person present with Ms. Fitzsimmons. That the department does not use body cameras. It is a violation of mass law to use deadly force against a person demonstrating a threat to themselves. It is a violation of mass law to use deadly force against a person only demonstrating a threat to themselves. So if she was trying to unalive herself, that would apply, right? Because she was a threat to herself and he shouldn't have acted with deadly force, aka Officer Noonan, who shot her. The unsupported he said, she said nature of these self-serving claims does not satisfy the clear and convincing evidence standard. As of the day of this incident, she was cleared to return to work as a police officer. Her license to carry was restored. She was scheduled to return to work on July 4th. That day, her significant other and baby's father betrayed her with lies and false allegations designed to take her baby from her and extract himself in the worst faith and cowardly fashion imaginable from the relationship. He told her to meet him at a local park and instead stood her and the baby up, and instead went and got an ex parte restraining order with an affidavit full of shocking lies. Kelsey went home and 3 male Andover colleague police officers came to the house serving the order, taking the baby, her future marriage, and her career with them all at once in the space of minutes without her even being heard or being able to defend herself. She never pointed a gun at any officer and only experienced a transient breakdown caused by surprise catastrophic circumstances. Kelsey was shot in the chest and has been hospitalized fighting for her life since June 30th. She is and is presumed innocent. She is also entitled to the presumption of personal recognizance. These immutable principles come together in this case to compel only one result: release on personal recognizance. Ms. Fitzsimmons denies the charges and maintains she is not guilty. Ms. Fitzsimmons has a devoted family and a 5-month-old baby who she earnestly wishes to raise, cherish, and support, and continue to assist in caretaking. She is a lifelong resident with very strong roots in the community. Ms. Fitzsimmons poses no flight risk whatsoever. She has everything to gain by staying with her family and fighting these abominable charges and clearing her name. She has also undisputed clinical support for her lack of dangerousness. This one was August 11th. We did read this, I believe, already, her statement. It is time, this is written by Bradle. It is time to end the PR war on North Andover police officer Kelsey Fitzsimmons. As Kelsey recovers from her life-threatening injuries, she cannot sit idle any longer. In our first press release, we were honored to speak for Kelsey when she was fighting for her life and she could not speak for herself. As stated, we would have preferred to address the facts of the matter in court, but Kelsey believes it's imperative that since she has been battered with leaks from negative and false allegations, she speak out now to set the record straight. Here's her statement. My name is Kelsey Fitzsimmons, and as I recover in my hospital bed, I am ready to speak about the incident that took place on June 30th, 2025, in my own home, where I almost lost my life. I was diagnosed with postpartum depression in March of 2025, approximately 3 weeks after giving birth to my beautiful baby boy. I have actively been in treatment since the day of my diagnosis and was eager to heal and feel like myself again. Unfortunately, the healing is a sickness does not healing a sickness does not happen overnight. However, what can happen overnight is that my life turning upside down into something so horrible, my mind wouldn't even be able to imagine it if it weren't my current reality. Someone who I thought understood my diagnosis, loved me in sickness and in health, and was in my corner for the journey of my active treatment to get better, turned their back on me. Said person is now legally bullying me to get what they want, slandering my character, and using my diagnosis against me to make me seem like I am a monster. There are more false allegations that I can even comment on. The deep love I have for my baby boy sustains me and keeps me strong. I haven't spent more than a night away from him since I delivered him, and I adore every moment I spend with him. He's my best friend, my miracle, my little man, my sweet boy, and most importantly, a giant piece of my heart. Right now, that piece of my heart is missing when I need it most. I am 5 months postpartum without my baby boy who needs me as much as I need him. I would never put the angel of a child in harm's way. My job as his mama is to protect him, and that is what I have always done and will continue to do for the rest of my life. Becoming a mother has always been my dream, and I have never made any threats towards my baby. The allegation specifically makes me sick to my stomach. I was alone with my baby in and day out for months, caring for him as my fiance frequently worked 24 to 48-hour shifts, but conveniently, there were never any concerns up until now. And I said that earlier, like if there was, why didn't he report anything or say anything exactly? I thought she said she wasn't trying to harm herself, or was it just him she said she wasn't trying to harm? I think she was just trying to harm herself. Is that cop that shot her close friends with hubby? I believe, yeah, they're all friends and work coworkers. She said she pointed the gun at herself and she was going to unalive herself. The other cop said she pointed it at him. Yeah. On June 30th, I received a phone call from my fiance to meet him at the park to go for a walk with our baby boy together. After almost 3 hours of waiting for him at the park and no communication from him, I went home very confused as he never showed up. About an hour later, I was sitting on my couch feeding my baby boy when I got a knock on the door. Very confused to see three of my colleagues, I opened the door and I am told the following. Your fiance followed a restraining order against you. He will be taking your son away with no contact allowed. Your firearms license that was just returned is gone. And oh yeah, the career you worked so hard for and love that you were just cleared to return to, that will be taken away too. Following this interaction, I packed bags containing my baby food, clothes, diapers, toys, etc. for my son to be taken away from me. I passed my son off to a fellow police officer and went into my bedroom. In that horrible moment, I didn't want to live after my whole world was turned upside down in the matter of 10-second conversation due to someone alleging horrible, untrue things. We have a broken legal system where someone can walk into a courthouse writing anything that self-serves them on an affidavit, and as a result, a brand new mother suffering with postpartum depression gets her baby taken away. We're calling on the legislator and the governor to reform this abomination of a statute where the first person to get to court and file a form can take a mother's newborn baby away from her, even from her if they can sneak in front of a judge without the mother's notice or opportunity to be heard. If there's an immediate issue, someone can call 911. The courts are not equipped for proper on-the-spot decision-making in the context without hearing from both sides. As a police officer, I am trained to know what to do if I encounter a suicide individual who is only displaying a threat to themselves. I certainly was not trained to shoot a suicidal person in the chest, But here I am today, 2 surgeries later, bedridden, and trying really hard to heal from these significant injuries. I am facing felony charges for a half-hearted attempt to take my own life. Let me say that again. I am in trouble and have a gunshot wound to my chest because in that awful isolated moment, I no longer had the will to live. I never pointed my firearm at the officer. That officer was not just a colleague, he was my friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. We entered the home and walked into something no human should ever see, a murder-suicide scene with a mother and her infant. As a rookie police officer, this was devastating to me. At the time, I was 20 weeks pregnant. The officer that shot me experienced this call with me. To this day, his support during that hard time is something I am still grateful for, regardless of the recent incident that occurred. This traumatic murder-suicide call was the catalyst for my mental health complications. As a police officer myself, I would never even think to intentionally hurt another police officer. I see everyone in uniform as my brothers and sisters. I especially would never hurt my friend who has a loving wife and children. I just would never. My firearm was never pointed in any direction other than my temple. When I pulled this trigger, my gun did not fire. However, I immediately got shot in the chest by my colleague and friend. I am extremely grateful for these two things, that God protected me from my attempt of taking my own life and protected me by millimeters from dying from that gunshot wound to my chest. I will survive and thrive. I know I need to be on this earth for many reasons, but most importantly, my beautiful son. This is my covenant with God and my son. I would also like to note that from the beginning, I acknowledged my diagnosis of postpartum depression and immediately sought help from medical professionals. I was failed by so many. The narrative has been released by NAPD is vague and non-committal for a reason. If body cameras were worn by my department, I would not be in the position where I am accused of pointing a gun at this officer. I know the truth will prevail. Kelsey Fitzsimmons. Yeah, I'm like big on the body cam stuff. This is a sad story. It literally breaks my heart. Motion for order of detention. The court has not been presented with a satisfactory release plan. Okay. Partial detention, pretrial detention, Officer Noonan. Okay. What is this one? I think we already read this one. Yep. I'm not going to read that part again. This is more docket. We're just kind of going through this big file. Okay. I want to right here. Conditions of release, bail, GPS, 24-hour house arrest, reside with her mother, stay away, no contact with the victim or her child, no alcohol with Scram, follow treatment by MGH, which she was doing all of those, except the Scram thing. 1119, habeas corpus for defendant issued to correctional facility. That's when I think she was brought back in there for failing to use the Scram. Okay, here's the affidavit we just read earlier from the ex. I don't know why they put it in there. Okay, we basically got it all done. On that one, let me see. This is a nightmare. Yeah, it is. I have a lot to say just because I have a lot of experience from mental health issues involving police and involving an ex. So like, I want to get into it, but I can speak from experience and years of it. Case header. Okay. Basically just docket entries. I don't think we're going to read much of this because this is just the docket. Justin, Kelsey Fitzsimmons caused me physical harm, placed me in fear of imminent serious harm, harming, attempting to harm my child, where the parents, okay, this is, yeah. Okay. Oh, this is interesting. We're gonna look over this. The Peace Officer Standards and Training Commission. Force. The amount of physical effort, however slight, required by police to compel compliance by an unwilling individual. Any use of force other than that which is considered deadly force that involves physical effort to control, restrain, or overcome the resistance of another. Um, it's basically just giving definitions. Use of deadly force. 1. A law enforcement officer shall not use deadly force upon a person unless de-escalation tactics have been attempted and failed or are not feasible based on the totality of the circumstances, and such force is necessary to prevent imminent harm to a person, and the amount of force used is proportionate to the threat of imminent harm, and the imminent harm poses an imminent danger of death or serious bodily injury to the officer or another person. The officer attempts as many de-escalation tactics that are feasible under the circumstances, including utilizing barriers where feasible, and the officer uses only the amount of force that is objectively reasonable. Yeah, I don't get why he just went straight to shooting her. Unless she was pointing really the gun at him. I don't know. I don't know without the body cams. A law enforcement officer shall not use deadly force at any point in time where there is no longer an objectively reasonable belief that an individual currently and actively poses an immediate threat of serious bodily harm or death, even if deadly force would have been justified at an earlier point in time. So they're basically referencing the training protocols. Findings and order. Okay, we already read that part. Hmm. If you guys want to hear the previous documents, there is a live where I did read some of these. It is alleged that on 6/3, members of the NAPD went to defendant's residence to serve her an RO. This also in NAPD is alleged that the whatever told that her weapons were secured in the basement. This writing is hard to read. Defendant's fiance arrived as she was actively grabbing her child's belongings. Pre-child detention. What is this list? Affidavit of Lauren Page regarding Scram device. We read the alcohol alternative. Remember why didn't they let her do a urine test or a blood test or something? This email is to Bradle from Jeffrey January. Oh, from the Scram. He says, "Hi, Tim. I'm sorry for the late email. It looks only like the alternative to Scram testing is testing with AverHealth, one of the vendors for probation. AverHealth testing would require someone to call the AverHealth number every day, listen to a recording which would notify her whether she is required to test that day or not required to test. If she is required to test, she would have to travel to one of the sites to submit a test. The tests are urine tests, not breath tests. I can give you more specific information tomorrow morning. If you need it now, feel free to call my cell." So there was alternative methods. Jeff, any Scram alternatives for people with asthma or COPD? They're basically proving that they tried. Not gonna read these today. I need to go see which ones I've already read. Okay, I think that's the end of these. I did read the 38-page article, the most recent one document, the most recent one. So there is a live on that. This matter came before the court, filed on October 2nd. The defendant seeks relief from order of Essex County Superior Court dated September 11th, held without bail. Incident report. Who filed this? Says incident description, include all individuals where it occurred. On 9/24/2025 at 9:15, Cedric Washington was on post in 1 Bravo when BOP inmate was escorted from cell 8 to medical. During this time, inmate Kelsey Fitzsimmons was in the sub-day room. As inmate redacted was passing by the sub-day room, he pointed at Kelsey Fitzsimmons. Oh, this was when she was threatened. On the way out of the unit, inmate stated to me, quote unquote, I found out something about that bitch while looking at inmate Fitzsimmons. At 9:25 a.m., I had inmate Fitzsimmons meet me on the rec to discuss the incident, to which she stated she did not feel threatened by his comments. At 9:31 a.m., inmate returned to the unit with his medical escort. While walking to his cell, he began pointing and screaming at inmate Fitzsimmons, who was currently on the rec deck, and stated, "You PC bitch. You best check out who you're effing with." I requested inmate redacted to stop with his comments, which he immediately complied with my request and locked in his cell. So that was the inmate that was like threatening her or harassing her in the jail. A trans lady threatened her. Yeah, that's really scary. So they were basically trying to prove that not in some kind of danger because she is a cop in jail. The probation officer was in court literally sticking up for her. You never see shit like that. I agree, Laura. I agree. And I have had scram before, and there's so many alternatives that they could have gave her. That's why they're saying and it's a women's prison. That's weird. Why point her out? They threw her in jump up. Yeah. Ooh, I know, it's crazy. That's dangerous because you know how inmates feel about police sometimes. Okay, I just wanted to go through that hearing, kind of go through some of the documents. I know I've read a bunch of these already, so I'm gonna go and pull the ones I haven't read, and I might want to read them. How long were her and her husband married? They weren't. That's the whole thing. At the time when this incident occurred in June, she was supposed to be married in October. So rather than being married in October, she like is in jail and lost her baby, and all of this has happened. So no marriage, all of this stuff going on. Here in Mass, we almost paid for someone to get a operation on the state's dime. Seriously, it was finally overturned. That's crazy. Yeah, I know. This case is pretty wild and upsetting all the way across the board. I mean, we don't have to say who we're sticking up for, whether it's or defending Kelsey or Justin. I think we can all come to the agreement that it's a terrible thing, right? Mental health issues and how those are handled. And if you haven't experienced that, well, look at you. Um, and then we know what alcoholism does to people as well. And toxic relationships. I mean, look at the Kenzie stuff. And corruption within police is a thing. So I think there's a lot of factors here. And I think I'm not judging Justin. I don't really know much about him, but I do think that everyone should be a witness and talk. The people at the party, friends, family of both, the police officers that were involved, the firefighters involved. Yeah. And we can agree that scientifically a baby does need his mother. It's very critical. I will speak on that. I'm not a pediatrician, but we do know that that could be detrimental. This case definitely has it all. I know. So trial February, whether she gets let out on bail again is a whole nother issue. I think she should be out on bail, maybe with supervised visits while still seeing mental health professionals. but maybe not. Maybe she'll be in there until February. So if once this trial starts, I'm definitely going to be covering it. I agree to extent it can also be detrimental depending on the circumstances. Yeah, it's sad. I mean, I don't have babies, but would you guys want your babies taken away at 4 months? I don't know. You mothers, let me know in the chat how you would feel about that and whether that would cause you depression if you were already going through postpartum depression. From what I understand, her parents can't even see the kid. I don't know if that's changed. Yeah. The grandparent issue thing reminds me of the Shanna Gardner case. That sucks. That really sucks. If she can't at least see her baby, I think, yeah, maybe her parents should be able to be able to relay information. I don't know. It's a sad case, but nonetheless, thank you for being here. We do have more lives planned later. I'm covering Christopher case, Christopher Schultes or Schultz, however you say it would cause death. Wait, what would? What would cause death? Christopher case, and then I might be doing a Kenzie live as well. 0 grandparent rights. Yeah, that's messed up. Like, what did the grandparents do? You know, they didn't do anything. And that's a source that she could, get the truth from and be comfortable with. You know. I do feel bad all the way across, all around for this case. It's terrible, but like I said, we would definitely be covering any more hearings that happen, new documents released, and definitely the trial tonight. Melly Kenzie live, maybe. Yeah, I'm thinking I want to do a couple more lives today. Taking my 4-month-old. Cree said, "Yeah, it would cause death." Exactly. That's what I'm saying. Imagine going through postpartum depression as well. Maybe Justin wanted out of the marriage and Kelsey could tell and alcohol feel raged at the party that gave Justin his ticket out. I think his parents were pushing him to the custody thing. Yeah. I don't know. I don't know if it's like against the law or whatever, but like, why don't they pull the text messages from the incident where her and her partner saw the mom and the baby get, where she unalived herself and the baby? Why not pull all of those text messages? Because I like with the Kenzie situation, we saw all those text messages. Like we can see if he was cheating on her. We can see what kind of relationship her and the cop Noonan who shot her have. We could see, what she was saying to her family and friends about her diagnoses. We can see what he was saying or whether he was setting her up, like all alleged, I think, I don't know. I don't know if the attorney said text messages and I don't know how far back they could go, but I think that would be interesting to see. I've had 4 boys, lost 1, and all were in the NICU at birth. I fought for those boys, and not having them with me after birth for weeks was so incredibly hard. I cannot even describe it. Thank you, Carrie, for sharing that because I am not a parent, but I know a baby needs his mom, and I know the mom needs their baby too. I can see both sides right now. Def want to see the evidence first. Agree, Tasha. Agree. So we all just will, hold our horses and making assumptions and whatnot, and just, I guess, wait and see what happens. It's sad. It's really sad. I don't know. Anyways, yeah. So I'll see you guys live. Please take this case makes me angry and want to cry at the same time. I know. She said herself that her and Nona had a great relationship. Noonan had a great relationship. They helped each other through the situation. Yeah. They are not looking for those texts. They're looking for the text closer to the shooting. Yeah, I could see that too. They probably wouldn't go back that far. I think it would be interesting though to see. We'll see. Nonetheless, please hit the like button on the way out. I will turn on your notifications so you guys don't miss if I do go live later. Today, it is Thanksgiving Eve, so I know people are busy and I know things are going on, but I mean, people are still on YouTube, so here we are. I might be going live, yes, later. So make sure you turn on Noonan. Where are you? Let's chat. Yeah, I want to hear from him. well, not like me personally, but like in the court or whatever. I say pull camera footage to see if anybody else was with him when he left. Oh, hotel camera footage to see if anybody was with him when he left to stay at hotel. That's a good one. I didn't even think about that. You actually read us an article where she was talking about him saying how close they were. Yeah, I think it was the one I think I read that one where she said the statement, and then another article I think I've read quite a few, I think, on this one. But yeah, the holidays, that baby going through postpartum depression, like, I don't wish that on anyone. I don't. And being incarcerated is so foul. But nonetheless, please hit the like button on the way out. I appreciate you guys for being here. Really, thank you so much. Shout out to my mods. I will see you guys maybe a little bit later today. And if you are not planning on coming back to the YouTube streets, then I hope you guys have a good Thanksgiving tomorrow. I will definitely be back later though. So if you're on, you know where to find me. I love you guys and appreciate you guys, and I'll see you on the next one.